Yes, today we're going to talk about intentional conduct. Last time we talked about the legal system to some degree. We went through all the way through what happens at trial and winding up talking about the appeal, which of course is you have a right to only one appeal, that's to the circuit court, and then your appeal to the Supreme Court would be subject to certiorari. That is, the Supreme Court chooses, for the most part, the court cases that it takes. There are some cases that it's compelled to take by the Constitution, but mostly it gets to choose what cases it's going to hear. And of course it tries to just take the most important cases and the ones in which need to be kind of cleared up in some sort of way. There might be a disagreement between districts. So the Fifth Circuit and the First Circuit might be ruling differently on the same kind of case. And so you need to have uniformity, so they might hear a case just to settle the differences between two circuits. Which one is right, or neither one of them right, or what. Anyway, so that's what we did last time. Today we're going to talk, as I said, about intentional torts. So intentional conduct, what is intentional conduct? Basically, a defendant must have substantial certainty or belief he will impose on others his wish. You know, and so he will be imposing upon the plaintiff something that the plaintiff wouldn't necessarily want. Like he might be touching him in ways that the plaintiff doesn't want to be touched, or threatening him, or he might be being careless and damaging him through his negligence. And so we're going to talk about intentional torts today, not negligence, not strict liability. Okay, so he must have a substantial certainty or belief that he will in fact commit a battery, or that he will in fact defame somebody. So he must have that certainty of belief in order to be guilty of an intentional conduct. So what is intention anyway? Basically, a defendant has certain desires and beliefs, and he acts to further them. This is then, he's doing this in order to further his goals, and so he's doing it with intention. He knows what he wants, and so he seeks to get it. So for instance, a young man might want to talk to his girlfriend, and yet she doesn't want to talk to him. She's breaking up with him, and he might have her in his car and refuse to let her out. That is, they'll be driving around and keeping her detained. And we'll talk about false imprisonment later. So it's an intent to do the act is an element that must be alleged and proven by plaintiffs in all the intentional torts, which is what we're going to be talking about. We're not going to be talking about all of them today. We'll talk about 5 or 6 of them. Anyway, now why do we have these so-called fault wrongs? Well, we want to deter people from doing them. That's one reason. So discourage people from doing them. And we want to provide compensation for the victim. So the victim might have had some sort of loss. If he was hit, if the person committed a battery against him, then he would want to go to a hospital and have his medical needs taken care of. It might include a certain amount of money for the doctor and the hospital and medicines and all kinds of things. So there's a long list of things that are required to be provided for a person like that. So all fault wrongs impose a legal cost on the wrongdoer. So the wrongdoer is ordered to pay, usually at least to compensate the victim. Sometimes with certain torts like trespass, you might not have any harm done, and in which case you might find the court saying, well, there was a trespass, but we're only going to give you nominal damages. In fact, there was one case involving the Reynolds case versus New York Times, I think it was. Anyway, the Reynolds case, the court awarded the plaintiff 1 cent. Some people say this is contemptuous damages rather than just simply nominal damages. So there are nominal damages, which are damages in name only. That 1 cent would certainly be that. Typically, these have been usually small dollar amounts, $5, $10, $1. But 1 cent, I think that was a record. Okay, and so the damages that are traditionally awarded in our system to people who file tort are either nominal damages or damages in name only, where there's no proof that any harm was done, or they're compensatory damages. Compensatory damages are to compensate the person for the victim for the harms that he suffered. So if he's got medical bills, those would be paid. If he has to pay doctors, those would be paid. If he loses time from work, those will be paid. His prescriptions will all be paid. His pain and suffering, that is considered to be part of the compensatory damages. So, and his time off work, lost wages, lost years can even be compensated for. So you can figure out how many years of his life he lost. And there are ways of calculating these things. And also, loss of consortium and other kinds of things are available. In the case of a wrongful death, you will get the money what the man would have made and would have been available for his defendants. There have been people who have tried to argue that if the victim is unconscious in a bed, not really knowing what's going on, he doesn't need as much damages. Well, I think that's wrong. You know, he's not suffering as much then, right? So actually, no court has recognized that as a reason to reduce damages. Thank God. Anyway, so compensatory damages pays victim for whatever losses he has, and these are things that he can usually prove as to that, usually sometimes with testimony, sometimes by other means. And so if his property was damaged, if it was in a car accident and his car was damaged, whatever it cost to repair or replace his car would be compensation. Now if he had insurance, that money's going to go to the insurance firm, but you know, there's no reason why the defendant shouldn't pay those if he caused those damages. Punitive damages, to deter wrongdoer and to vindicate the victim. So punitive damages, at common law, they were unrestricted. They could be any amount, and oftentimes were set by the degree of wealth that a person had. So if a person was very wealthy, then he'd be made to pay a lot more damages, and maybe millions. And so some people say, well, gee, these people are getting a windfall amount. This is a huge amount of money, you know, and thought that was a terrible thing. Well, the lawyers also got some of that, so they weren't complaining. It was just the press and people who generally don't like the way the legal system worked thought that it was. One of the key things about the punitive damages, in our system, traditionally, the plaintiff and the defendant, the litigants, all pay their own expenses. So the plaintiff who brings a suit has to pay his lawyer. Otherwise, that's some sort of violation of ethics. You know, although nowadays, of course, lawyers take these tort suits on a contingency basis, and it's agreed that, except for maybe expenses, the plaintiffs will not pay anything. And actually, oftentimes the lawyers will just ignore the fact that the plaintiff didn't pay them, and maybe they'll collect it when they get the money, both the expenses and whatever their share is. And so obviously the compensation must be a serious case. There must be a big amount of money to motivate a lawyer to take the case, because he's not interested in a case that's only get $500. It won't pay him to go to court for that, to write up the briefs. He's got all these expenses concerned. He has to pay his secretary, he has to pay his clerk, he has to pay his cost, and you know, it's just not worth it for him, and he's got better opportunities elsewhere. Okay, deterrence and compensation. All fault wrongs impose a legal cost, and so you have nominal, compensatory, and punitive damages. This obviously is meant to be a big deterrent. The Supreme Court has said in the 90s, it said that these punitive damages needed to be proportional to the compensatory damages, therefore setting a limit on how high they could be. No longer were juries able to say, well, this man is 3 times as wealthy as these other individuals, and therefore we're going to charge him 3 times as much punitive damages for wrongful behavior, because it takes that much, doesn't it, to maybe deter him. But the court seems to be ignoring the element of deterrence in that regard. Not very good economics, huh? Anyway, fault wrongs, intentional conduct, is what we're talking about here. Okay, and so I'm going to go over assault, battery, false imprisonment, trespass, defamation, intentional infliction of emotional harms. You know, those last two have had considerable change in recent years. As a matter of fact, the last one, intentional infliction of emotional harm, didn't exist. There's also negligent infliction of emotional harm, but we're not talking about negligence today. And of course, negligence is a fault wrong. So it's the last one listed here, but I listed it as unintentional conduct. You know, negligence is where you didn't intend to do the harm. You didn't intend to drive your car into that car. You didn't intend to, you know, knock that person down, cause him to break his hip, but it happened. Should you be liable for it? Well, it was an accident, but you know, he still got those expenses. And unless he collects from you, he has to bear those expenses himself. So our traditionally, our system has been that a person who negligently causes harm is at fault. And so we'll talk about negligence probably another night, but we'll go through its elements. It's relatively simple. If we have time, I might just mention the elements of it there. Anyway, let's first talk about trespass. I want to do trespass first, even though it wasn't first on my list that I just gave you. Trespass is intentional, unconsidering, entering in, or causing something to enter upon a land or somebody's property, somebody's building. This is a trespass. So trespass could include you're walking down the beach, it's a public beach, and then it suddenly changes to being a private beach. There may or may not be a sign. It's nonetheless trespass, okay? And you're liable for the harm that you would do when you trespass. So if you left footprints in the sand, oh, there's no harm because this is going to be wiped out by this tide, right? Tide's going to come in and go out. If you, on the other hand, stomped over some bushes, or if you got curious and wanted to see what was on the other side of that wall and you climbed up and looked over the wall and invaded somebody's privacy, those are all harms that you would have to pay for the trespass. On the other hand, most people who trespass are like the person walking down the beach. They don't notice a sign, or there is no sign, and they don't see it. And they just walk right onto the beach, on to wherever it was. So the intentionally unconsidered entering is what we're talking about here. Now sometimes you cause something to go upon the land. So if you, let's say you have a rubber band airplane, you know, one of those rubber band airplanes, you wind up the propeller and you let it go and it goes onto somebody's property. That would be caused by your action, and you would be therefore liable for whatever harm that airplane would do. I doubt if it could do much, but you might wind up having to pay nominal damages again. If nothing else, you know, there's a cost to cleaning up. If you're throwing litter onto somebody's property, maybe they should be able to collect for that. So if you dumped your garbage on there, I'm sure there would be compensatory damages for that. Cleanup costs, right? Anyway, so trespass. So you're dumping somebody's garbage, even though you didn't step on the land yourself, you're still liable for the trespass. Or causing somebody else to dump it. So you pay somebody to dump it, and you know they tell you they're going to dump it there, or you know they're going to dump it there, or you direct them to dump it there, and they do so. Both of you are liable in that case. Even though he's an agent, he should know better. And you're liable because you are the master in that situation, and he's the servant. Anyway, trespass is obviously has to be intentional, and it has to be private land or premises of another. So if you go into the post office, you're not trespassing. And also, it's not merely entering. Sometimes it's remaining in, say, a bar when you've been told you have to leave. So I've been trespassing like that. I remember when I was dating my wife, she had a chair, and I sat down on her chair when she went to the bathroom in order to save her. Then a man who knew she'd been sitting there and saw that I sat down tried to tell me it was his seat, and I said, no, it's not. And I wouldn't get up. So he talked to the barman, and apparently the barman knew him. And then the first thing you know, the guard showed up and wanted me to leave. I said, I'm not leaving until my girlfriend comes back. Well, I wasn't worried too much about the guard because he seemed to be an older fellow, probably in his 70s or maybe 80s. I don't know how old he was. He seemed ancient. Anyway, I just defied him. But luckily, my wife came back just as from the crowd stepped an officer of the law. And he didn't have to show me his badge. I knew he was an officer of the law. I think I knew him. And when he told me I had to leave, I left. But I was actually trespassing there for a while. They didn't pursue anything on that. Typically, a lot of people are not going to pursue it. You know, what was the harm that I was doing? I was just sitting on a bar stool. So it doesn't seem like that would be very much harm. And also I know that bouncers have to be very careful not to injure people when they remove them from a bar. So that scene you see in Roger Rabbit where the gorilla throws the detective out into the alleyway, that's not what bouncers do. They usually are very big, strong, and scary guys, but they might try to bluff you, but they know that the owner doesn't want to do anything that would harm you, so they're going to just ask for you to leave, and then if you don't leave, they will contact the police, and the police will tell you, and if you don't leave then, the police will arrest you. And so, trespass is something that a lot of people have done. So remaining when you've been told to leave, if it's private property and the owners or the people who are managing or running the place tell you to leave, then you have to leave. Otherwise you're trespassing and can be arrested. The private land or premises of another. So plaintiff can be made to pay nominal damages or compensatory damages if proven. For instance, let's say you were out in the woods and it was a blizzard. Came up suddenly, you were caught out in the woods, and you saw that there was a cabin. And so you went there to find shelter, knocked on the door, nobody answered, nobody was in there. So you broke the lock, you entered, and you stoked up, there was wood there, you lit up the fireplace, and there was some provisions there, you ate some provisions. You're going to have to pay for the lock, you're going to have to pay for breaking and entering, you're going to have to pay anything that you broke or used or destroyed, like the firewood, you would have to pay for. If you started a fire, you'd have to pay for whatever damage you did. It doesn't matter if there was an emergency. You're going to have to pay for what you used because you are still trespassing. So we like to say about some torts, and this is certainly one of them, that it's the conduct, not the intent to do harm, that we are punishing. That's not true of all torts, as we'll see later on. Defamation and infliction of emotional distress, some of those harms have become something where it's important what was the person trying to do. Was he trying to cause harm? And it's always been important if you're trying to collect damages to show that there's harm, even if it's not a case that requires proof of harm in order to get nominal damages. You know, you typically don't want to bring it for nominal damages because you can't pay for your court costs. Battery. This is an intent to contact, an intent to contact through an act to cause unlawful or unconsented to contact. So it's unlawful, unconsented to contact, and a contact that's harmful and offensive, or offensive. It doesn't have to be both. It can be harmful, it can be both, or it can be otherwise offensive. And the contact can be direct. You punch the guy in the nose, that's direct. You hit him over the head with a hammer, that's direct. On the other hand, if you pull his chair out from under him and hits his butt on the bottom of the floor, that's contact. His butt came in contact with the floor. You intended him you intended to do that. Perhaps you thought he wouldn't be very badly injured and wouldn't make a big deal of it, but you wind up getting sued because you did some harm. So for instance, if you do strike somebody like that, you're responsible for it. Let's say you hit somebody, you commit a battery and you hit somebody in the jaw and you break his jaw. The jaw is a very big, hard bone to break. Typically a person's jaw will not break. You'd have to be generally very, very strong to break a jaw. But there are some people who have been previously injured, maybe a boxer or somebody who's been previously injured in some sort of accident, and they have what are called glass jaws. If you hit that person, you're responsible for the harm that you did. So the fact that the injury was much more severe than what you thought it would be doesn't matter. You're going to have to pay for what it costs to fix that glass jaw and for the pain and suffering associated with that glass jaw, which is probably going to be greater than that which would have been the case had he been an ordinary person with an ordinary jaw. So direct contact or indirect, falling on the floor, pulling a tray from a man's hand and telling him that he has no right to be here, that you don't serve his kind here, those would all be batteries. Okay? So direct or indirect contact, either one. As long as you intended to make that contact, you're responsible for it. Assault. Assault is intentionally causing a reasonable apprehension or a reasonable fear in somebody else. So for instance, if a 3-year-old came up to you and told you they were going to punch your lights out, it wouldn't be reasonable to think that you would be in fear of that, and therefore you couldn't sue that 3-year-old for that assault. You would maybe engage in a little play with him a little bit, and you might even let him hit you, but you know he's not going to do any harm. And so it's a reasonable fear. There has to be an imminent danger, basically a present danger. It's likely to happen soon. That's what imminent means. It's going to happen soon. So if somebody points a gun at you and is threatening you, you know, and tells you, okay, give me your money or your life, that's an assault. He hasn't shot you. He hasn't committed a battery, but he has committed an assault. And you can collect damages for assault, for the fear that he caused you. And so harmful and offensive conduct. So in some ways it's connected to battery. Both of them involve harmful or offensive conduct and contact. Plaintiff is actually placed in fear. You know, it must be that the plaintiff is placed in fear by it, reasonably so. So that's why I say it has to be reasonable that you are placed in a state of fear with the tort of assault. False imprisonment. We alluded to that. What are the elements of false imprisonment? These elements you have to prove. In every case you have to prove intent, because these are intentional torts. You have to prove that the defendant desired and intended to hold plaintiff against his or her will. So there's going to be restraint and confinement. That would be another element that you have to prove. I got all these listed on the PowerPoints, which will be made available to you. Restraint or confinement by use of force or threats, usually. But however you do it, trickery, it could be done by trickery. So you lead a person into a room and you've got a key to the outer door, and as you leave you lock him in. You have falsely imprisoned him, right? You haven't used force. You could argue that that's the use of force and that the lock is the force, but is that not the kind of force where you carried him in there? He walked in there of his own free will. There can be no escape for him if he can escape. So it has to be a bounded area. It has to be someplace that he cannot safely escape from. So for instance, there was one case involving a man who had been left on a rooftop, and the defendant tried to argue, well, he should be able to escape because there was another roof 3 feet away that he could jump to, a little lower than him, and he could jump over 3 feet to that other roof. Whether he can jump over it or not, he shouldn't have to risk his life jumping over a roof, over to another roof, and therefore it's a bounded area. And so you see this most often with buildings and rooms and cars. If you're in a car and the guy is driving, you can't get out of the car. You've maybe got control of the locks, even when you come to a stop. You know, and so you are confined. And I think this happened to people. And the people who do it oftentimes maybe don't realize that they are committing a false imprisonment, but they are nonetheless. And also false imprisonment includes unlawfully arresting somebody. A citizen can't arrest somebody if they've seen them committing a felony. If they're holding, they can hold them for police, so to speak. This is a very limited kind of exception, and you have to be very careful not to exceed the privilege you have to do that. False imprisonment. So defendant intended to hold plaintiff against his will. There was restraint or confinement. There was a bounded area, and the victim knows he's being restrained, or he knows he's being confined. He knows that, you know, you've locked him up or locked him away and are not honoring his desire to get out, and you somehow are therefore violating his rights as well as giving him cause to sue you for whatever damages the court and the jury finds. Juries, to some extent like this, some of that would be, some of it might be actually something you could directly calculate. Like, for instance, did he lose some time from work because he was locked up? Was there other things that he lost out on? Parties, even. Was there things that he had bought tickets to the theater, he didn't get to go to the theater, you know, because he's locked up. And so he'll be able to collect for his damages and for suffering that he had being there. So so there, with false imprisonment, you get all those. So, yeah. Defamation. Defamation is the intent or careless damaging of the reputation of another. In this case, the damages are presumed. So we have what's called special damages in defamation. So when Carol Burnett sued the National Enquirer for having a story in it that said that she was an alcoholic and that she was drunk a lot, and which was a terrible lie, because anybody who knew her knew that she didn't drink at all. Her parents had been alcoholics, and because of that she basically swore off alcohol. She never drank any alcohol whatsoever. So she found it very offensive when the National Enquirer said that she was an alcoholic. She had, in the movies and on television, portrayed drunks because she said she wanted to show how silly drunks are and discourage people from being in that condition. She thought if she showed them the ugly side of being drunk, that would maybe help them to avoid drinking. It's because she's seen the ugly side of it. And so she sued them, and she got, I think, like almost $2 million or something, $2.5 million maybe. How did they calculate those damages? The jury just puts a number on it. These are special damages, just presumed. She doesn't have to prove how many people heard it. I mean, that might help if you can make some sort of estimate as to how many people would have heard the thing. That might actually increase your damages if it's a lot of people. And in her case, it probably was. With the National Enquirer, probably a lot of people saw the headlines, and that would have been enough. There has to be a false statement. In this case, the false statement is that she is an alcoholic when she's not drinking anything at all. And it's about this victim, so it's about Carol Burnett. The headlines identified her. If it doesn't identify her, then it's not going to be liable to anyone. It has to identify a person for that person to sue. If it names people in general, if you say that all men are abusive to all women, there's nobody defamed because you said all men. So that's not singling out an individual, though. On the other hand, if you say that all Republicans are abusive, not only is that not true, it's also, but it's not something you can sue for because nobody is identified. But if you say that a certain president, a certain black president, was guilty of carelessly using his email accounts, then you would be defaming the only president that was black that we've had. So if you didn't matter that you didn't name him because people could identify who it is talking about. So the important thing is that you have somehow identified him. Could be by name, could be by characteristics that he has that similarly people can figure out who you're talking about. And so it has to be about the victim. And it has to be published to a third party. Publishing means just disclose. It has to be disclosed to some third party. You have to send it by letter, or you have to say it. They can see it on TV, they can see it in the newspaper, they can see it, they could hear it at a speech that you give. It's published to some third party. In other words, if you come up to a person and you tell them all kinds of terrible things about them that are untrue, you tell them that they're drunk, and you tell them that they are insane, you tell them that they cheated on their wife, and none of it's true, there's no defamation because there's no publication to a third party. But if a third party overhears it, there is. And the other thing is, now you also need to be careful that you don't repeat gossip. If you repeat gossip, if it's defamatory, then you are a defamer, and you could be liable for repeating gossip if it's not true. So somebody tells you a story, it's a juicy story, it's an interesting story, you want to tell your friends, refrain yourself. And the best thing to do is what I did when that happened to me. Was one friend of mine from law school had told me about a mutual friend we had and his wife, and said that he had been caught in flagrant delicto by his wife. Well, I had reason to believe that he might be right because I'd been with his wife and him numerous times. But it turns out that he was not right. I called up the man and I asked him, and he denied it, said it didn't happen. I didn't call up her, I didn't know her as well, although we all had gone to the same law school. I just simply had never really had that much contact. She was in a different class, and it's just simply somebody I knew through him. And so you don't want to be doing that. And so I said to him, why don't you sue this secretary who says that she caught you this way? He says, well, she's unemployed, we fired her, and she has no money, so it's a waste of time and money to pursue her, which is quite a reasonable explanation. And the truth, as far as I'm concerned, is that nothing really happened like that. So there has to be an intentionally careless damaging of the reputation. So here's a case where the intent is to damage the reputation, right? Why would you say things like that? Well, really it doesn't matter if in fact you didn't intend to damage the reputation. So my friend, maybe he didn't think about it. Maybe he didn't think about it damaging the man's reputation. It doesn't really matter because he did the thing. And so, but oftentimes people who are defaming oftentimes have a malicious motive. And if they have malicious motive, that's usually going to increase your damages. Also, it's a necessary element if you're talking about a public figure. So if you want to say something about the president, you know, if you say it with malice, actual malice is what it's called, you could be sued for defamation. Now you might say, well, people say all kinds of terrible things about the president. Why is that not actual malice? Some things that you say about people will not be seen as defamatory, like calling people very common names, like saying somebody's stupid, or saying somebody's an idiot, or, you know, and there is an idiot classification. I mean, one can actually take an IQ test and determine what somebody's IQ is, and there's an idiot level. You know, still, despite the fact that that could be said to be a factual issue, it's usually treated as being a matter of opinion. They're not trying to really say that he has been tested and has an IQ score of a certain level. They're just saying that they just don't think that he's doing very well intellectually. Or, you know, so if he's in the public eye, if he's an actor, if he's an athlete, he's a rock star, he's somebody that's on TV a lot, then he's in the public eye. He's a government official, he's the governor, he's the mayor. He's the publicist for the mayor. Okay, you know, they've all got to be careful, and you know. But you know, if you're simply saying things about them, you've got to have some basis for saying it. Usually, the newspapers require two corroborating sources. Okay. And so that's what the newspapers have, and by that way they avoid the ideal that they're acting with actual malice, which is actual malice exists if they should have known better. And they're a newspaper, they should investigate the stories that they run and not just simply pass it on. They can't say, oh, we're passing it as a newspaper. They can't say, oh, we're passing this on because it happened, you know, it was reported in another newspaper, or it was reported on the news, or you know, they've got to have actual sources. And then they have to be reporting it. Now, this is rather interesting because recently there's been, in the case of internet servers can publish something that's defamatory, that's put on by somebody on their website. They don't look at those things, they don't publish it in the same way that newspapers do, so they're not held to the same standard as newspapers. Recently there was a rather interesting case involving a teacher by the name of Sarah Jones. In 2012, she was convicted. She actually wound up agreeing to a plea deal in which she confessed to having had sex with her boyfriend. Before that plea deal was enacted, I believe there had been a story circulating about her, and there was this one group on the internet that was publishing these stories. And so she sued them for defamation. I think it must have happened before the lawsuit was there. Anyway, she actually won that lawsuit, but that was in two, 3 years later. That was overturned by the Court of Appeals, the Circuit Court. It was overturned, even though she, you know, well, you take it she had confessed to having had sex with her boyfriend, although she had first denied it. And she continues to deny it to this day and says that all they were doing was exchanging emails, you know, or text messaging. So there was a lot of text messaging. There was something going on with this boy who was 9 years her junior. She was 26, he was 17. Now in Kentucky, 16 is the age of consent, so there's no illegal conduct there, but it is illegal and wrong for a person to have sex with a young student like that, certainly high school student. And of course it's looked down on even with college students. But I think it's a different story that there are sometimes affairs that go on between students and professors. Was that an abuse? Well, maybe sometimes and maybe sometimes not. She argued and he said, and the parents of both of these two said that this was consensual on their part, that if they were doing it, it's because they both wanted, and she, I think, later married him. And so she had been a Bengal, which kind of brought her to attention of people. So she had a weekend job. In the day, she would be teaching school, high school English, freshman English, and on the weekend she would be a Bengal cheerleader. Okay, so anyway, that was a rather infamous case. You can find lots about her on the internet if you're interested in looking up a case on that. And that's the case where in some degree she is in the public eye as a teacher, especially she sort of put herself in the public eye. But if it happened before actually she came into the public eye, then maybe it's not. It's maybe what brought her into the public eye. It certainly was what brought her to the attention of the police, who investigated her and subpoenaed the texts from that. Her mother got convicted of telling the boy to get rid of his phone because they found out that the police were using the texts. And so she was convicted of trying to conceal evidence. I think she got like some weeks in prison for that. So she and her daughter were both in prison for a while. Anyway, so about it's a false state. There has to be an intent to damage the reputation, and there has to be a intent to say something that's going to damage the reputation. There has to be a false statement. It has to be about this victim. Okay. About this victim, the person who's being defamed, who's going to become the plaintiff. It has to be published to a third party. We went over all that. It has to cause harm to the reputation. So because she was a teacher, it was definitely harmful for her reputation to have stories saying that she was having sex with a 17-year-old student, or had sex with a 17-year-old student. I don't know, is texting, is that having sex? I guess that's sexting, right? Anyway. In cases of public interest, an actual malice must be proven. And so in her case, I think you have to show actual malice on the part of the thing. But also there is a statute that eliminates liability for internet servers who are publishing statements made by other people. It doesn't eliminate defamation because you can sue the person who actually made the statement, and you can even subpoena and get the record. And this is why you see the internet servers all want you to give an email and give information about who you are before they give you an email account nowadays. That wasn't always true. But since that statute got passed, they now want to know who you are because they could be subpoenaed and asked to tell who it was. And if they can't produce that kind of documentation, they may then be held liable. Okay, so those are the elements of defamation. Defamation can be what's called libel, which is written defamation. You see that in a newspaper. Or it can be slander, which is spoken defamation. Traditionally, libel would give you almost automatic damages. And so you would get automatic damages for libel. As I said, that was actually what Carol Burnett got. And, but for slander, you typically didn't get automatic damages. You're going to have to prove who heard it, how many people heard it, how much was it spread around. You maybe need to come up with an estimate about how many people might have heard it. And so that's going to limit how much damages you got, because the size of the audience is where the harm comes in. And in fact, even slander, though, can be passed around a lot. I don't know if it was ever published, the stories about Jefferson and Sally Hemings, whether that was actually published in a newspaper. It may well have been. I don't think he brought a lawsuit on it, probably for good reason. but it was probably better for him to keep it quiet. To publicity of it was maybe a bad thing. And so you see this a lot still even today, where people say, well, publishing it just makes it worse. Okay, so there are privileges in defamation. You have a privilege to say things in certain venues, such as in executive proceedings, agency proceedings. An executive agency has proceeding, and you would be privileged to do that. Or the president is interviewing you, and so he's asking you about a particular candidate who he's considering to be somebody he might nominate to the Supreme Court, and you have some juicy information, and you say, well, I've heard this. Now, that's going to be privileged, so it's an absolute privilege for you to talk to the chief executive, and the ideal is that the chief executive then will not spread that information around. Instead, he just announces, well, I'm choosing this person. He doesn't go into detail as to why this or that person was decided against, but in some cases it might have been that somebody had some dirty laundry that they thought was going to be a problem. And so the executive, if you're dealing with the executive hearings, that's an absolute privilege to say things that otherwise might be defamatory. Maybe things that you don't actually know. You only know that there's a rumor about it. In which case then he can investigate it, call the man in and ask him, call the woman in and ask her, is there any truth in this? I've heard this story. Okay. And also there's an absolute privilege for judicial hearings, same way, testimony and the arguments of the court and the arguments of the attorneys, things that are said by witnesses. These are all absolutely privileged. And so I had a friend who was being prosecuted, was getting a divorce, and his wife claimed that he had beaten her. He was famous. He was a head of the SEC Enforcement Division, and that made national news. And of course it damaged his reputation very much, but she said it in the courtroom, so he couldn't do anything about it. He denied it, but doesn't everybody deny it, so it doesn't seem to make much difference. These are absolute defenses. Whether it's judicial and whether it's legislature, like presidents also have hearings, and things you say in there will be absolutely privileged. Now that doesn't mean you can talk about something that is not the topic of you have to talk about the things that are at issue. So if it's a case, it's got to be something related to the case. If it's a presidential nominee, it's got to be related to his being a person maybe that would be subject to being cross-examined by the Congress, right? So it's got to be related to what's at issue. And there are also other protections. You have a justified right to protect private interests of you or another. That is, for instance, if somebody stole your wallet and you're just running away, you can yell, "Stop, thief!" Well, maybe you're wrong. Maybe he wasn't the one who stole your wallet. You got bumped into by a couple of people. You think it's this person, but it's not that person, and maybe you're wrong. You have a right to say that about yourself, and you have the right to say that about others. Stop, thief! So you're saying the person's a thief, and you're pointing to him. People know who he is. He's identified. Maybe he's caught. Justified to protect a shared interest of the group also could come into play in certain circumstances. I'm not sure if I got a good example for that. Above, these are qualified examples, and they can be lost by abuse, such as repeating them when it's really not time to repeat them. So saying "stop, thief" at one time, and then later saying the man was still a thief, I know. Later, when you're found out that he didn't have your wallet and didn't take your wallet, you can't continue to say it. Okay. Intentional infliction of mental and emotional distress. When I entered law school, I don't think this was actually a cause of action. You could not get damages except for things like a battery or assault. And mostly, it was difficult to get any sort of damages that were based upon mental or emotional distress. Even with assault, oftentimes they would want you to show some sort of physical harm done. But that has changed. And so this is a tort in which there's an intent or there's a reckless maliciousness to it. A person intends, and this is a case that's totally different than, say, the trespass case where you didn't intend any harm, but in a case like this where you're intentionally inflicting emotional distress, you're going to have to show that the person intended, because it says that he intended this emotional distress that is in it. So There you do intend the harm. So this is a difference from what common law usually provided for. It didn't require you to intend any harm. And still in lots of cases, like in trespass and even other kinds of cases, battery, sometimes a person didn't intend any harm. Say, oh, it's just a practical joke. Yeah, I put the bucket with the water over the door, but I didn't realize it was going to ruin his new clothing or cause him to catch a cold, or that he would have some sort of allergic reaction, or that doesn't matter, or he'd slip and fall after the water on the floor. So the intention or reckless malice, that is reckless negligence, if you would. Actual and malicious cause. There has to be, you're wanting to cause somebody to do this, so we're talking about maybe approximate cause, actual and malicious cause, severe or extreme anxiety created in the victim. You need to show that, you need to prove that it affected this person badly, so he'll probably need to testify as to his sleepless night, his consultation with his psychiatrist, his inability to do certain things anymore. I have a sister who feels very bad about leaving her house alone and nobody's there, because she had burglars break in one time and steal $3,000 from her, which she had laying on a counter, which is maybe not a good place to keep it, but that's still her house. She should be able to do that, right? So, but she's got this emotional distress from that. And the thing is, she wouldn't have sued those individuals. These were actually two boys who had shoveled her snow, and she paid them for it. They later came back and they stole her money. They saw where she had her money, and they came back for it, $1,000. But the police caught them just by accident, if you would. Not at the house, but somewhere else. And they began to question them, where'd you get all this money? And they figured it out. Mental and emotional and actual damages. There has to be that. Okay, so those have to be severe and extreme mental or emotional actual damages is what you're going to get. It also has to be an extreme and outrageous conduct. So it's something out of the ordinary. A man goes up and knocks on a door and tells the woman inside, your husband's been in a car accident, he's going to the hospital. She's pregnant, and she goes to the hospital because she's very upset, and there are complications with the birth, and they think it's due to him. So, she was severely affected by that worry, and so it's extreme and outrageous conduct of some sort. Something out of the ordinary, and that's ordinary, not just an ordinary insult or an uncomfortableness, which is kind of happens all the time to people. You can't claim, well, my boss told me I wasn't doing a good job and get intentional infliction of emotional distress. That's not going to happen. You need something extreme and outrageous conduct. I mean, this is ordinary behavior. You can't say, well, the same really goes with defamation. You can't sue if somebody reports something. If your employer says that you actually are doing a bad job, and you're not a very good worker, you can't sue for that, because that's a matter of opinion. So, fact would be something that could be objectively measured. And so it's on the evaluation, and those things are very carefully worded so that all the supervisor has to do is mark a box, either yes or no, or a certain degree, 1 through 10, depending on how good is his job. And that's just becoming a matter of opinion, the way it's written. So you never can get damages on a case like that. Unless, of course, he says something outrageous and extreme. And so what would that be? Oh, you're an axe murderer. That you could sue him for. I had a client come to my office one time and told me that she knew that her former employer was giving a bad representation for her, and she'd been told that she would be given a report as to why she left there, but instead they were telling people that she wasn't doing a very good job. That's why they got rid of her. I would advise anybody in business not to do that, although I think it's unlikely that you could be sued for saying that. Extreme and outrageous conduct, it has to be, for intentional infliction of emotional distress. Okay, so that's that for intentional infliction of emotional distress. Next we're going to be talking about strict liability, and that'll be maybe amongst other things, and negligence. So we'll talk a little bit about strict liability very briefly, and then we'll get into negligence. So next time will be largely negligence. Thank you very much, and I hope you've enjoyed this lecture as much as I've enjoyed.